and we're recording now, so we're going to get permissions and consents from those people who are visible to put this on YouTube. And everybody else, please, while we're recording, keep your cameras off. If you're not speaking, please stay muted. And welcome to this information session about right-to-work checks for non-EEA citizens. So today's focus is slightly different from the other information sessions we've done, which were about EU citizens and how the right-to-work checks are changing for them now that the grace period is over, Brexit is complete, freedom of movement has ended, and they are subject to right-to-work checks in the same way as, or in a slightly different way, actually, as third country nationals have been for some time already. So a little introduction about myself and what we do here at Citizens Advice Liverpool. My name is Cozy Durfel-Hill. For the last 2 years, I was in charge of the EUSS project, which is grant funded by the Home Office to help people with making applications to the EU settlement scheme. And I have now recently changed jobs into another project. I'm now the partnership coordinator on the Access to Justice project, and with that I run the Access to Advice network. So part of that role is also running information sessions, and I was able to take that with me. Getting EU citizens out of the way quickly before we get into the nub of non-EEA citizens. The deadline for making applications to the EU settlement scheme was on the 30th of June, but our project is continuing. So if you have clients or employees, or if you know anyone that hasn't made an application but is eligible to apply under the EU settlement scheme, i.e. they're an EU citizen who was resident in the UK before the 31st of December 2020, the end of the transition period, then please do refer them to us. The contact details are already in the chat. It's euss@caliverpool.org.uk, 0151 522 1725, and our wonderful team of advisors will be able to help them with making a late application, because the Home Office is indeed accepting those. For EU citizens who were granted a status under the EU settlement scheme, there is a separate website where they can check their status and where they can obtain a proof of their status. There is no physical proof of the status for them. They don't get a little card. They don't get a document or anything they can print or a stamp in the passport. Nothing like that. It's purely digital, and they have to go to the website called View and Prove, log in with their passport number, their date of birth, receive an SMS for two-factor authentication, and then they can generate a share code, which can then be emailed to their employer. The employer then has to open the email and follow the instructions in that and access the website themselves. So far, so good for EU citizens. And now for the next nearly hour and a half, we can talk about non-EEA citizens, where things get a lot more interesting. And this year is actually seeing the biggest upheaval to immigration law in the UK, probably since 1971. I don't know if Aka would agree or disagree with that. I'm sure he'll tell us in a minute. But it's not only seeing the EU settlement scheme come to an end and new rules applying to EU citizens, it's also seeing the introduction of the new points-based system, which is an evolution of the system that already existed, but it is still representing quite a massive change. And just now, in the last couple of days, the government has proposed a new legislation governing how people apply for, how people claim asylum and how asylum seekers and refugees are treated. I'm not going to go into the violations of human rights that entails, because I'll never stop ranting if I start. So with that, I think I'm going to hand over to the wonderful Ake from Migrants at Work, who is much more knowledgeable than me on the subject. So over to you, Ake.
Thank you. Hi everyone. So my name is Aki Achi. So I'm a director and founder of Migrant at Work. So in terms of my background, I have a master's degree in international human rights law, a degree in international relations. I have worked for the trade union for a number of years, so I have seen how migrants are supported, from the trade union perspective and from the employment perspective as well. And I'm currently doing my SALEX employment qualifying employment lawyer course. So I really have the inside of the right to work check as a migrant myself, but as a trade union official. Yeah. So when we talk about the right to work for a non-EEA, we have to include EU citizens as well, those who have arrived in the UK after on or after the 1st of January 2021. So they fall into this group. So the difficulty with the right to work is to understand what a statutory right to work is. What is really important to understand is that the determination of migrant immigration status is extremely complex. That's the reason why employment, the work is being done by the Home Office. However, the determination of the statutory right to work itself extremely easy. It's either the individual is qualified by reason of his or immigration status or is not. So even though the determination of the immigration status itself is quite complex, to determine whether somebody has a right to work or not is really easy. So there is no gray area. So it's either you have the right to remain to live in the UK and you have the condition that apply to your leave to remain, and those conditions allow you to work, or it doesn't. So there is no gray area really. But if migrants are not disqualified, they cannot be committing any criminal offense. So if you have no legal right to work, it doesn't matter whether you can show the evidence to your employer or not, because your legal right to work is in the law. As I always say, it's not the document that gives rise to your right to work, is your immigration rules. So if your immigration rules give you the legal right to work, whether you can prove it or not, it's another matter. So migrant will establish a statutory defense against an illegal working at all time if they have the legal right, the statutory right to work in the law. It doesn't matter whether they can prove it or not. Or in terms of getting employment, it's gonna be more difficult because obviously they have to show a document to employers not to confirm the immigration status, but for the employer to establish a statutory excuse against an illegal employing offense, which again is another thing. So the question is, who has the right to work? So to understand the statutory right to work, then we need to look at the general principle of immigration control. So the Immigration Act 1971 provide the framework for immigration control and decide who is who is subject to immigration control and who is not. So once you have that piece of legislation, then you need to add the immigration rule. The immigration rule are rule by which people who are subject to immigration control can be granted status subject to conditions. Those conditions can include being prohibited or restricted from work. So, for example, an irregular migrant are prohibited from doing any work. So, when we talk about an irregular migrant worker, we have to make the distinction between an irregular migrant worker and an undocumented migrant worker. When we talk about the right to work and migrant, we often mix everything. We talk about undocumented migrant worker when in fact people are referring to individual who are irregular migrant worker. And a lot of people in the industry are saying that uh, we should not label individual. I agree, we should not label individual, but in the terms of immigration law and the right to work check, if we do not label migrant, then we take the risk of those migrants being denied the legal right to work. So, for example, if we take an irregular migrant worker and an undocumented migrant worker, an asylum seeker, for example, will be an irregular migrant worker, then it will not have the legal right to work. An undocumented migrant worker will be, for example, somebody who has, I'll take the example of EU citizen, for example, who have a certification of application, which is a valid immigration document, but will not be an accepted, which will not be a document that is accepted to to for employer to allow that person to work. So in this situation, we will say, well, that person is undocumented because he does not have the right document. And I think it's really, really important to make the distinction in order to be able to properly support individuals. So once you have the immigration, you understand the Immigration Act 1971, you understand the immigration route. You also need to understand that the Immigration Act 1971, in conjunction with the Immigration Order 1972, grant exemption to some people who are not subject to immigration control. So if you are not subject to immigration control, there is no restriction on your right to work. But it's really unlikely that employer would have these kind of people working for them. So they might be, for example. So it's unlikely that it will be working for employer, and it's unlikely that frontline migrant support organization will be supporting this kind of individual because they're in the same sphere, I would say. Um, so once you have determined the individual immigration status and its actual right to work. Of course, it happens that when that individual has the legal right to work, at some point, the visa, the leave would expire. And that's where it become a little bit complicated. Not in the law. In the law, it's quite simple, but it become complicated for employer to establish a statutory um, excuse. So the statutory excuse is basically the government allowing the employer to breach immigration law, provided that comply with the guidance. So when it comes to that, so we're talking about continuing leave to remain. So if an individual has a valid leave, that leave is about to expire and it has renewed it before it expired, the leave continue as if it has never expired. So the right to work will remain the same. The only problem is that for employer to be able to maintain this continuing statutory excuse, that individual needs to provide evidence to the employer to be able to do that. The problem is when you submit your application for the variation of leave, you do not receive any confirmation from the Home Office except an email. But that email is not considered an acceptable document. It is considered as an acceptable immigration document for the individuals to prove their right to remain in the country, of course, to work as well. But somehow, it did not make it to the list of acceptable document for employer. So you have on the one hand, the Home Office is telling migrants who are subject to immigration control, your leave is gonna expire. We allow you under the law to renew your leave, therefore to continue to remain in the country to have the legal right to work. But we're telling employer that the document we're telling you that is a valid immigration document is not acceptable for the employer. That's where you see this gap. It is acceptable for migrant, but it's not acceptable for employer. In this gap, that's where labor exploitation happens. So people fall into this gap, and you can't get away with that because when you are in this gap, some employer will say, well, I know that you don't have the legal right to work, which is wrong. But because many migrants also do not understand, sorry, do not understand the right, then they will say, well, okay, I need to work. And some employer will say, well, I can carry on employing you, but I will pay you under the minimum wage. Of course, if nobody else is offering you work and you have to feed your family, you're gonna accept that. You don't have a choice. So that's how, in a way, immigration law conflict with employment law, create this vulnerable environment where migrants are being exploited. Section 3C leave set out three conditions that the individual must meet to get continuing leave. So first, you must make a valid application to extend your permission. Your leave, your continuing leave, it must be before it expired. And permission must expire before the Home Office make a decision. One of those preconditions are once those preconditions are met, the leave-in will continue. While the application remain undecided, while you can bring an appeal or apply for an administrative review, while an appeal or an administrative review is pending. So really, unless you have a final decision from the Home Office, you still have the legal right to work. Your right should not be affected. That's in the law. And in practice, it will never matter because since employers have difficulty to establish a statutory excuse for a legal employee against a legal employee offense, then they don't really know what to do. And if employer then believe that you have the right to work, but because you can't prove it, so therefore they cannot employ you, an employer find themselves in a situation where they could face legal claim for race discrimination. But if they get that person on board, continue to employ that person, but in the end, they get it wrong, then the Home Office can fine them. But if that person has the legal right to work and the employer has been fined by the Home Office, then this becomes an illegal fine. And that is really important to understand because there are many employers who are paying those illegal fines without realizing that they can challenge the of a fine from the Home Office. And I think that's really, really important to understand. So what are the category of people who have the right to work? So we can put these individuals have the legal right to work in four categories. So you have people with a right of abode. So if you have the right of abode, for example, you're a British citizen, you are free to take up any employment without any restriction. That's in the law. But in practice, it doesn't work like that, as we have seen with the Windrush scandal. People have the legal right to work, but they can't prove it because they do not have the right document. But there is nothing in employment law that says that the employer is not allowed to employ somebody because of the immigration status. What immigration law says is that if you employ somebody who does not have the legal right to work, then you may be fined. But employer do not want to take the risk. That's the reason why we heard about the Windrush scandal. But before the Windrush scandal, this has been happening since 1971. So it's nothing new. But this came to light with the Windrush. So the second category are people who are settled in the UK. So it could be, for example, somebody who has indefinite leave to remain, that you are settled in the UK. So therefore, there is no restriction your employment. The third category are those who have time limited permission to stay in the UK and whose right to work is also limited. And those one may be subject to restriction. So, for example, if you are on a work visa, if you're on a work visa, so for example, for a skilled worker, if you're on a work visa, you might be on a work visa for 2 years or 3 years, depending on your immigration route. Um, you might be sponsored to get to work as a nurse, for example. And if your condition is work as a nurse, so you have permission to work as a nurse. So the condition is your nursing, okay? But then at the end of the month, for example, you have extra bill you want to pay, and you find a job somewhere as receptionist in a hotel, for example, and you want to take up that job. Because this is not part of your condition, that you will be in breach of your immigration condition, and your visa will be potentially revoked, and you will be removed from the UK. So it's simple as that. So you have people who are exempt. So the fourth category are people who are exempt from immigration control. So those one again, they are free to take employment because the right to work check does not apply to them. Right to work check apply only to those who are subject to immigration control. So really the full category, people have the right of abode, and those who are exempt, the right to work check does not apply to them. But because employer is required to carry out the right to work check for all the employees, obviously employer will be asking British citizen and those who are exempt from immigration control, if they are working for that employer, to provide evidence of their right to work just to avoid and direct discrimination. So employer will do that. So really, so these are the four categories. So who are affected? When we talk about non-EEA nationals, so we're talking about refugees. Refugees do not have any restriction. So if you're a refugee and you're in the UK, you can work, you can take any employment. If you're an asylum seeker, then that's another problem. A free group of asylum seekers. The first one are those who are in detention. So those who are in detention are not allowed to work, but of course, in those detention, they are working, but they do not have they do not have any employment right, even though the work they're doing fall under Employment Right Act 1996. They don't have any employment right. So you have those who have submitted the application, the asylum application, and that application is being considered by the Home Office. Again, they don't have the legal right to work. And you have the third group, those whose application has been pending for more than 12 months, they can submit a request to the Home Office to get permission to work. Permission can be granted or can be refused. If permission is granted, then there is another challenge because when asylum seekers have permission granted to work, the Home Office issue a document. And with this document, according to the Home Office policy, they're allowed to work and to take any employment. Well, depending on the condition, they're allowed to work. But those conditions should not prevent them to do the actual job they've been permitted to do. But the reality is that it's difficult for employers to employ asylum seekers that have permission to work simply because the document they receive from the Home Office, which allow them to work, is not again listed as acceptable document. So we come back to the point I said earlier, where the Home Office is telling an individual in this particular situation, asylum seeker, you've been waiting for more than 12 months. You requested permission to work. We grant you permission to work. We'll give you the document to work. That's a legal immigration document for you to work. That's great. But then they are telling employer, this document we have given to him is not acceptable. Again, it's another situation where asylum seeker have the legal right to work, but cannot work because the document is not acceptable. Generally, they should be issued with what we call our card. But there are some asylum seekers who have never been issued these card. So therefore, again, they cannot work because they had a permission to work, but they do not have this card. It become really, really difficult for them to work. And again, they fall into labor exploitation. And the third group, so you have all the migrants. So that's what I was saying earlier. It's really, really important to label migrant individual or workers, because if you don't label refugees, asylum seekers, and migrant, if you put all of them in the same category, or you confuse asylum, a regular migrant and a document migrant worker, the right they have, you may not be able to protect those rights because of the confusion in the legal term. So the third group, as I was saying, are all migrants. So these include those who are settled and those who have a work visa, including EU national. The EU national arrive in the UK after the 31st of December, then fall into this group of all migrants who need permission to come to work to work in the UK. They will be sponsored to come to work in the UK. Again, they will have to meet the condition. They will have permission. That's great. Need to meet the condition. And once they have once they meet those conditions, then they have to work only in that particular job. They cannot do any other job. And we know that, for example, there are some employers who will assign them in a specific role. Or for example, if somebody is off sick in that particular workplace, they will ask this individual to fill in for the other one. And this is a breach of the immigration condition if it's not part of this condition. So sometimes you want to help, so you don't want to be seen as a troublemaker. So you want to help your employer. But by doing that, you're taking serious risk of breaching your immigration conditions. So this will be, for the individual, this will be a serious problem because the visa can be revoked and they could be removed from the country. And employer also face risk as well because they will be employing somebody who is disqualified by reason of the immigration status, but they will not be working according to the condition. So when will all these individuals be affected? So they're affected at several levels. First, at the recruitment level. For the employer to establish a statutory defense, they have to ensure that they carry out the right to work check. So not statutory defense, statutory excuse. They have to make sure that they carry out the right to work check before they employ the individual. Now the question is the before. When is the before? It's either is it either during the recruitment stage while the application is being processed or during the interview stage. So there is a lot of confusion here. But if the employer refuse or put some, as we have seen it many times, before you even apply for a job, the employer asking, they have set this online system where they're asking you what kind of a immigration status you have. So because some of the immigration status are quite complex, if, for example, for somebody who is subject to Section 3C leave, if you ask that person at a very early stage, do you have a valid uh, leave, for example, and can you prove that leave? If that person take yes, I have a valid leave, can you prove that person might take no? because that email they received from the Home Office is not considered an acceptable document for employer. So employer might already discriminate against individual have the legal right to work even before they get to the um, the interview stage. Because what the law says is simply you have to make sure that you do not employ somebody who is disqualified by the reason of the immigration status. The employer can go through all those stages, and the day that person is supposed to start their work, they have to ensure that that person has a legal right to work. But many employers do not want to go through the whole process, and then at the end, realize that that person does not have the legal right to work. So because of that, some employers are carry out the right to work check before they arrive at that stage. And again, they could potentially face race discrimination claim if they are refusing to employ somebody who has a legal right to work, but they couldn't capture that immigration status because of the system they have set up, the recruitment system they have set up to identify those immigration statuses. So it might be challenging for employers. The other time where they are affected as well is when the visa expired. As I said with the Section 3C leave, when the visa expired, is quite challenging for an employer. When also you are on a sponsorship visa and your salary changes as well, these become a serious issue. If your salary goes below the income threshold required for you to obtain that visa, then that create a problem where that individual would not meet the immigration condition. The other stage where it creates a problem is during the 2P transfer. So the 2P transfer is a serious problem as well because when an employee transfer from one company to another, the current company has to provide what we call the employee liability information. And the employer liability information must include the identity of the person, the age, the terms and condition, any activity, any active disciplinary grievance record, ongoing cases from the last 2 years. This is a legal requirement. What is not included in there is the right to work check. So if you're a new employer who has bought a new company and you're transferring all the stuff to you, and you check the employee's liability information and you don't see anything in there, you will have to carry out the right to work check. And even if you see in there, you still have to carry out the right to work check because you don't know during that time, you don't really know what has happened at individual immigration status. But if the Section 3C leave was valid for that person, sorry, if that person has applied to the section to renew his leave and it's been 2 years, for example, and you have bought the company 2 years after they submitted the application, so you don't really know what is going on. So that person can tell you, I'm still, the section 3C leave still apply, but you don't know. If you don't carry out as an employer, if you do not carry out this right to work check, then you will be liable. But if you carry out the right to work check during that time, it happens that while that individual has a valid leave to remain into work because the Section 3C leave apply, when you carry out the right to work check, you don't always get a positive verification notice from the Home Office. Simply sometimes because the application takes quite a long time to be assessed. Employer's guide to right to work check usually says it takes 5 days. But we have seen cases where people haven't heard anything from the Home Office for years. So it's quite challenging. And from the day of the 2P transfer, you have 60 days from that day to carry out the new right to work check for that employee. So during these 60 days, if you continuously contact the Home Office, obtain an update, but you do not get that update, then you will say, well, I cannot continue to employ you because of immigration status. But if that application is in process, then the employer potentially could expose themselves to legal claim as well for discrimination. But what we have seen is that what many and some employers are doing is that they prefer, which is wrong and legally wrong, they prefer to transfer all the individual who have current valid immigration status, and that is illegal. An employer should not do that. So that's some of the issue we see. Um, if you recruit worker from overseas, then you would need you would need a sponsorship for them to come to the UK to work, and that's one. So we're seeing now the statutory right to work. Now, when we talk about the statutory excuse, as I said earlier, the statutory excuse is the Home Office allowing the employer to break immigration law if they have carried out the right to work check. The problem with that is employer believe that they have a statutory duty to check that individual immigration status, and that it cannot do that because what the right to work check does not determine the immigration status of that individual. It merely confirms the immigration status of that individual at the time they are doing the check. And because the immigration law is so complex, again, I give the example of the Section 3C leave. If you are doing the check for that individual and you cannot get confirmation from the Home Office, but that person still have the statutory right to work, then that person is not in breach of the immigration condition. So therefore, they will always maintain a statutory defense. So because the employer cannot establish a statutory excuse, does not mean that they are in breach of immigration law. So there are two ways for employer to establish a statutory excuse. First is through the right to work check, then they would establish the first statutory excuse. The second one is a statutory defense by making a determination on individual immigration status. When you read the Employer's Guide to Right to Work Check, that guide only talk about one way of doing that is through the right to work check. But I'll quite often say that the right to work, the guides, is misleading. It's because the employer guides, the right to work check, is only for employer to establish a statutory excuse. It's not made for employer to make a determination on individual immigration status. It's not made for that at all. But because employer do not understand the law and immigration law, and rightly so, because immigration is not a business. The business is to make money. So because of that, it becomes really, really, really difficult for the employer to understand this distinction. And the Home Office make that clear in the employer's guide to right to work check. They say that we recommend you use our right to work checklist to ensure you have correctly carried out all the steps you need. So this is a recommendation, not a law. But many employers believe that the employer's guide to right to work check is the law. It's not. Although the order, which says that the employer must establish a statutory excuse by using the online checking service, that is the law. But the problem we are having here with the statutory excuse and the statutory defense, because the statutory defense is under the primary legislation, so the Immigration Act 1971. The statutory excuse is an order. So what the order does is that it asks the employer to obtain some information which are contrary to Immigration Act 1971. So I'll give you an example. And I take the Section 3C leave because it's a lot easier to explain. So when that person has applied to renew the leave and they have received that email from the from the Home Office, that email confirmed that they have the legal right to remain in the UK and to work, provided that they have the legal right to work before the leave expired. So under the Immigration Act 1971, the employer has established a statutory excuse because that person has the legal right to work. It's simple as that. But then with the order says that you need to obtain a positive verification notice. Immigration Act 1971 does not say that. So you have the two legislation that conflict with one another. And this makes really, really challenging for employers. And in the guidance, what employer says is that the duty of, what the Home Office says that the duty of the employer is, that says, quote, all employer in the UK have a responsibility to prevent illegal working. You do this by conducting simple right to work check before you employ somebody to make sure the individual is not disqualified from carrying out the right to work check in question. So when the guidance says that, the guidance is referring to the Immigration Act 1971. When you do the right to work check, you cannot always determine whether that person is disqualified because the right to work check, the online right to work check, is not a real-time system. So as a result of that, you will get a negative response from the right to work check when in fact that person is not disqualified for carrying out the work by reason of the immigration status. Once you've done this right to work check, that's where you obtain the statutory excuse, and you will not pay for a fine if that person was working illegally. But as I said earlier, if you receive a negative notice from the Home Office, but that person still, so the negative notice you have, it will be under the order. But if that person still have a valid leave to remain under the Immigration Act 1971, then the employer cannot be fined by the Home Office because they are not in breach of immigration law. Now, in terms of the right to work check itself, there are three steps. Before we get to the online check, there are three checks for non-EEA national. Brexit hasn't changed those checks, even though this has been indirectly affecting non-EEA national. The right to work check for non-EEA national has been the same for a very, very long time. So there are four steps. So first is the free physical check. The employer has to check your document, passport, it could be a visa, it could be any document that are listed by the Home Office as acceptable. Again, acceptable does not mean acceptable under the order does not mean it's not acceptable under the Immigration Act 1971 and the immigration rule. So once they have checked the document, they have to make a copy of the document and they have to store the document, and all the check need to be done in front of the individual. If they have carried out the right to work, the physical right to work check, and they are not too sure that the individual had the legal right to work, that's when they have to go online and to carry out the online right to work check. What often employer always do, not all of them, but many employers do, as soon as you give them the document, is they carry out an online check right away. And why they are doing that, it's not employer's fault at all. And the reason why they are doing that is because the order from which the recommendation, the employer's guide to right to work check has been drafted from, says that the only way for the employer to establish a statutory excuse is to carry out the right to work check, the online right to work check. So you have on the one hand a Home Office saying that for non-EEA national, you need to carry out the physical right to work check. But on the other hand, they are saying that the only way to establish a statutory excuse is to perform an online right to work check. So if I'm an employer, I'm confused. On the one hand, what should I do? Carry out the physical check or the online check? And if I do the online check and I don't carry out the physical check, and that person is telling me, look, I have my document, I have the legal right to work. Why are you carrying out the right to work check? And employer are doing that for British citizens as well, who have a British passport, and they carry out the right to work check when British citizens are subject to immigration rule, and employer are facing race discrimination claim again. So the whole thing is really, really, really confusing for an employer. And this kind of session we are being today, it's really important for employer to and to try to understand, even though what I have said here might be confusing, but it's because the whole thing is confusing for everyone. I think I'm going to stop there because that's too much to say.
Thank you so much, Ake. Yeah, I think certainly I can empathize with the fact that the immigration system is built in a confusing way, and a lot of work needs to go into actually simplifying that. And although the government keeps saying that that's what they will be doing, and the Law Society has instructed the government that they need to be clearer about their wording, about the language they use, and things are progressing and efforts are being made in that general direction, it's still very confusing. So if you think it's going to be difficult to see the wood for the trees right now, brace yourselves, because I'm next going to hand over to the wonderful Jennifer Mirdamadi, who is one of our volunteer advisors at Citizens Advice Liverpool. And she has, I think, for about 3 years now, been really the go-to person for immigration queries. So Jennifer is going to tell us a little bit about the kind of actual problems clients come to us with. So over to you, Jennifer.
Okay, so am I the presenter now? How does it work?
You're spotlighted. If you want to present something, if you have something that you want to present your screen, then you just click on. Anybody can present, by the way.
Just on the share content. Yeah. Okay, so I'll just start by saying that this is, something I have been concerned about for quite a few years. In fact, years past quickly. I think it's a lot more than 3 years now. I was just going to say about one of the first clients that I dealt with where this sort of first hit home to me, and that was definitely more than 3 years ago.
It might be about 5, because I've been with Cal for 2 years. I think it was 3 years when I started.
Yeah. So I've just given a couple of examples of a couple of the cases that shocked me when the clients came to me, and then I'll just talk about what the most common cases we're seeing now, where people have difficulty proving their right to work, and then I might finish off by quickly showing you by sharing my screen exactly how the right to work checks can be carried out in practice, because your mind may have been blown by everything that Aki was telling you, but don't give up. So one of the first clients that came to me was a young man who'd come to the UK as a child, as a refugee who came through resettlement, so gained indefinite leave to remain right from coming to the UK many years before. And he had the kind of document people were issued with then, before they invented plastic biometric residence permits. He had an immigration status document that clearly showed he had indefinite leave to remain and had the right to work. He was unemployed, was on job seekers allowance, and his job coach, or whatever they called them then at the job centre, was instructing him to go to certain job interviews to look for work as a condition of his benefit. But every time the employer was refusing to employ him because they didn't accept this immigration status, this document, this piece of paper, as proof. It said he needed a biometric residence card permit. This was even though this immigration status document was at the time illustrated in the guide for employers, which has since been removed, the guide that shows you actual pictures of the documents you can accept. And his job coach was refusing to believe him and refusing to believe he was turning up to the interviews, and thought he was making excuses and threatened to sanction, that is, stop his benefits. At each time, and only believed him that he went to another interview and secretly recorded the conversation on his phone covertly, probably wrongly, but he did, covertly recorded the conversation with the employer, played it back to the job coach, who was astonished, because you have to bear in mind that people would not be getting job seekers allowance or universal credit if the DWP had not checked that they had the right to work. So it's complete nonsense, where one part of the government, there's no joined up thinking, because the government wants to get people off benefits and into work, but despite the best efforts of the job centre, they couldn't convince employers that people they were sending to them had the right to work, so they had to stay on benefits. In the end, this poor client had to borrow money to apply for a biometric residence permit, cost of £229 that he didn't have. And the job centre manager refused to my suggestion that they should contact the employers themselves to explain that such persons did have the right to work. Another client soon after that was someone who'd been in the UK since the 1980s, had a letter from what was then called the Immigration and Nationality Department on a very crumpled piece of paper from the 1980s, saying that he had indefinite leave to remain and right to work, a sort of letter that was definitely not illustrated in any guide as an acceptable document. He done a degree, he had a good graduate job for about 30 years, tried to switch to a new employer at the same workplace, and they refused to accept this document. And he objected to having to pay this £229 to get a permit to prove what he already had proof of. I eventually realised this was a Windrush case, because he'd been in the UK so long, and helped him via Windrush to get his biometric permit for free. And luckily, in this case, the employer kept the job offer open for months. So he was lucky in that regard. I would say the most common problems that we're coming across is employers demanding to see biometric residence permits from people before they will employ them. Because that's the most common kind of proof people have, and it's simple, it's easy. It usually just says, it will say if they don't have a right to work. But at the moment, there are so many people that for different reasons don't have biometric residence permits. Some of this is purely technical, due to delays at the Home Office. They're very, very slow to issue these permits after people have been granted permission to stay and work in the UK. And this has been exacerbated by COVID, where it can take 4 or 5 months for somebody to get that permit after they've got their leave to remain. The other situation that Ake alluded to is where people's time-limited leave to remain comes to an end. Maybe they're already employed on that basis of that, and the employer says, well, look, your leave to remain has expired. But if the person applies within the last month of that leave for further leave to remain or indefinite leave to remain, their right to work does continue with the same conditions. I mean, their leave to remain condition continues while the Home Office considers the new application, including their right to work. This is what's known as 3C leave, which is a bit of immigration advisor jargon, but it's one that's worth knowing. It refers to Section 3C of the Immigration Act, and it means that while you're waiting for new leave to remain, your rights continue. The problem is, again, of course, they don't have a biometric residence permit or any document that proves this. And as Ake said, an email proving you've submitted an application is not accepted. The Home Office used to send a letter until a few years ago saying your rights continue, and that letter used to be acceptable, but they don't send letters anymore. So we're finding that all sorts of employers are struggling with this. It's from big international companies like Deliveroo, for instance. We've had Amazon, who have, all the human resources staff that you might want, and so on, but it doesn't. They have processes, and the requirements of the Home Office don't fit with those processes, like demanding that somebody must send a scan, an image of their biometric residence permit, but they haven't got one. And at the other end of the scale, we have very small employers, like a small care home. It could be a corner shop, could be anybody, who just panic at the idea, the threat of a £20,000 fine, and just are too scared to employ people unless they have certain documents, usually the biometric residence permit, which is very understandable. And of course, recently, this is now this category of people without a biometric residence permit has been extended to EEA nationals, who of course are not going to be given one at all, and use a totally different system called View and Prove to create a share code to give to the employer. So that is confusing employers as well. And when it comes to the non-EEA family members of EEA nationals, who have rights under the settlement scheme as well, depending on when the EEA national arrived before the end of December, they have been given biometric residence permits, though our experience now is that when those permits run out, they're not being renewed. So again, there's a category of people who are coming across this problem of not having this magic plastic card. So I think it might be helpful if I just briefly share my screen and show you the process of how to deal with all these different situations, in case you're about to throw up your hands and think it's all too complicated to deal with. So I'll just share my screen if that's all right. Or does anyone have any questions first? Are there any questions on the chat at all? Yeah, I can't. You're muted, Cozy.
Silly me. There were some questions submitted in advance through Eventbrite. We're going to go through them.
Yeah. I mean, we'll leave it till after
Q&A. Are you happy for this to still be recorded? There's not going to be anything confidential on the screen. Okay.
Yes, it's just government web pages I'm sharing. Okay.
So, yeah, I mean, yeah, let's aim to finish that by about 10 past at the latest, so that we have at least 20 minutes for the Q&A.
Okay, okie doke. Right, so hopefully this will work. Right. Now, can you see my screen? Can you see a government web page there now?
Yes, we can.
Excellent, excellent. So I think the simplest way to sort of sum up the different methods of checking a job applicant's right to work, or indeed a current employer's employee's right to work is to start from this page, which is part of the gov.uk series of pages, employ someone step by step. Okay, so this is the step about the right to work. Now it will shows two options here. It really should show three options, like what if the person doesn't have documents, but that is covered at the bottom of this page, but for some reason they don't have a link to it. Okay, so first thing, if they have a share code, you can use a particular method of checking their right to work. Now this will apply to all EEA or EU nationals and their family members. So clicking on there, check details of a job applicant's right to work. You will need their date of birth and their right to work share code. Now this share code is something they will have generated themselves by going to a different page where they put in their details, and it comes up with a magic code, a time limited code, which they can give to you, the employer. Okay, so that's the first method, which is the most recent method, and it does apply to some migrants who are nothing to do with the EU settlement scheme actually as well. Right, so the second method is to check their documents. Okay, physically check their documents, and that link will take you to another page which allows you to work through various different options of documents. So do they have a UK passport? No, in this case. Are they naturalised a British citizen? No, we'll say. Are they let's say they're not British, not from the EU, from somewhere else. Do they have a current passport with an endorsement? Let's say no. And if not, do they have a biometric residence permit? No. And then maybe they have an immigration status document, and so on, and so on, and so on. Right, just to go back though, because what I want to come to is the situation where neither of these methods can be used. They haven't got a share code and they can't show you an acceptable original document. What it should have here is a third option.
Sorry to interrupt, Jennifer. Apparently it's not showing your screen moving on. So it's still on the first page.
Okay. All right. Okay. That is a shame, but you should know that, okay, you can follow one of those options, but if they have a share code, it's all fairly explanatory after you click on those options. So if they have a share code, that takes you to a page where you can put in the share code and date of birth, and it will tell you if they've got the right to work.
Jennifer, please, could you just share the link, the actual URL to the page you're on in the chat? Could you pop that in the chat for us?
Yeah, I'll do that now.
Fantastic, thank
Copy.
you.
I think I can. So I do this. Okay. Okay. Is that there? Okay, so and then the second one, if you follow that, it goes to a series of pages that says, have they got a passport with a stamp? Have they got a BRP? Have they got a this? Have they got a that? Okay, but supposing they haven't got a share code and they haven't got the documents which you think are acceptable, so whether they are acceptable or not, you don't think they are, right? You can then go to the bottom of the page for the third method, which is if the job applicant cannot show their documents, you must ask the Home Office to check the employee's immigration status. If you're reasonably satisfied they can't show you their documents because of outstanding whatever. So you can use this link, you know, if they say, well, I've got the status, but I haven't got the card yet, or whatever it is. If they can't show you the documents, don't worry too much about this restricted number of bullet points here. Whatever the reason, go to immigration. So now, can you see this? Use the employer checking service. Well, sounds like you probably can't from what you said before. So I'll put that in the chat as well. Okay. So this takes you to another page again, which is a pity you can't see it, because but if you can follow
well,
it.
actually, I can see it. So I think some of us can see it and some can't, and hopefully it will be on the recording. So by all means, do show us the pages you want us.
Okay,
Want to
so
show
that
us.
then has a big green button, start now, and then goes through a series of questions. The first one is, do they have a passport from the UK, etc., etc.? No. We'll say to that. Do they already work for you? Let's say no, a prospective employee. And then, now this is the important one, which I wish you could see. It's now got a list of circumstances. It says, do they have an ongoing application or appeal for leave to remain? So that would cover these 3C cases where someone has put in an application in time, so their rights continue. So you could choose that. It has an application for no time limit to be added to a new passport. Various different circumstances then where, so an application for a replacement biometric residence permit, for instance, that would be where their biometric residence permit was lost, stolen, destroyed, or whatever, and they've applied for a new one. It covers that case. A certificate of application issued to an EEA national. So again, you could choose that circumstance. Unable to produce a valid biometric residence permit due to non-delivery or collection. That is very, very relevant because there's so many of them are getting lost in the post or not delivered for months, as I said. Or unable to use digital right to work due to technical error. So almost any circumstance is covered, even another one, none of the above. So then you can click on next. And one last important question, has this person been in the UK since before 1988? So if you say yes to that, this is covering the Windrush type situation. Let's say yes, they've been in the UK that long. So finally, the result of all that is you need to ask the Home Office to conduct a right to work check. So that gives you another, takes you to an actual form where you put in the employee's name, date of birth, nationality, address, job title, various other things. And once you've submitted that form to the Home Office, they are then supposed to come back to you. As Eki said, it's supposed to be within 5 days. Won't necessarily be, with a verification of their right to work. So I'm sorry to have just rattled through that, but I think it's really important to show you that there is, in practical terms, a method that covers this situation where there are no documents, or even that you're not sure that the document is one of those on that list, or they say they've got it but it's lost or whatever. So I just wanted to give you a bit of hope there. The one last rather more depressing thing to end on is that it doesn't always give the right answer. we know situations where it says the person has no right to work when actually they do. But let's say that in most cases that will come back with the right answer from the Home Office. So that's at least a starting point. So I think I'll stop sharing my screen at this point, but you can ask questions about that if you want to. And I'll leave.
Thank you so much, Jennifer. I did spotlight you, so I'm going to stop spotlighting you now, which means I'll be visible as well. What I'm going to do is I'm going to stop recording. So thank you so much to our speakers. Unless, Ake, is there something you wanted to put sort of to add on after what Jennifer said, or are you happy that you covered it all before in your presentation?
Yeah, just what I would just wanted to say is on the list, on the step Jennifer went through, it could have happened that the Home Office come back saying that the person has the right to work, or the person's right to work has not been withdrawn. However, that person cannot work because they do not have the acceptable document. Then the Home Office will then advise that person to apply for a biometric resident permit. And in the meantime, because they have received that information from the Home Office, then what the employer would do is to suspend that person. But of course, the information they receive from the Home Office is misleading, because as the Home Office has accepted that that person's right to work and have been withdrawn, that person therefore has a legal right to work. And if the employer then suspend that person, and quite often the employer withhold that person pay, that's where we fall into labor exploitation. An employer is going through a dangerous path when they're doing that. But again, it's not the employer's fault. It's because they received the wrong information from the Home Office.
Thank you very much for that addition, Ake. I think it's really important to bear that in mind, that actually employers can almost slip and slide by accident into situations where they're committing criminal offences. So on that happy note, I'm just going to finish off the recorded part of the session, and then we can move into the questions and answers. So thank you so much to our speakers, and hopefully this will go up on YouTube so you can all share it far and wide and refer other people to it. And that should stop.